Hello students, today we are going to discuss about Article 20, Clause 2. It deals about the concept of double jeopardy. In previous video, I explained about Article 20, Clause 1. With that continuity, today we are going to discuss about Article 20, Clause 2. The concept of double jeopardy is based upon a legal maxim nemo debet bis vexari. It means the person should not put in danger twice for the same offense. So the person should not be punished twice for the same offense. And then we have two legal terms. One is atrefous acquit. That means previously acquitted. Next one is atrefous convict. Previously convicted. These two legal terms can be taken as a defense by the accused person. For example, A convicted under IPC, later once again the case has been initiated for the same offense under IPC against A. In this situation, the person can take a plea of atrefous convict. That means he can say that already I have been convicted for the same offense. So in this way, the plea of atrefous convict can be taken by the accused person. Then, based upon these two concepts, the concept of double jeopardy has been inserted. Article 20, Clause 2 states that no person shall be prosecuted and punished for the same offense more than once. Before the enactment of the Indian Constitution, the double jeopardy concept was incorporated under Section 26 of General Clauses Act 1897. To understand this concept, we are going to discuss few case laws. The first one is Maqbool Hussain versus State of Bombay. In this case, a person came from the abroad and he reached airport. In airport, the authorities found that he was having a gold, which is against law in India. Immediately, the gold was confiscated by the concerned authorities and action was taken against him. Later, he was prosecuted under Foreign Exchange Regulation Act. Now, the important question arises whether the case comes under Article 20, Clause 2 or not. Because initially, the custom authorities imposed a fine for the possession of the gold. Later, he has been prosecuted under Foreign Exchange Regulation Act before the criminal court. The Supreme Court held that the fine imposed by the authorities does not come under the term of punishment. Therefore, the trial before the criminal court is not barred because he is not punished twice, because the imposition of fine for an offense does not come under the concept of punishment. The next case law is State of Bombay versus Apte. In this case, a person was convicted under Section 409 of IPC. Later, the prosecution was initiated against a person under Section 105 of Insurance Act, which deals about wrongfully obtaining or withholding the property. So there are two different sections has been imposed on a person. Now the Supreme Court held that even though the case has been filed under two different sections, both sections have different ingredients and both sections can't be treated as one offense. Two different offenses are there. So Article 20 Clause 2 does not apply for this case. The next case is Mukhtiar Ahmed Ansari versus State. In this case, the case has been filed in two sections under IPC. One is kidnapping, another one is extortion. Along with that, the case has been booked under Arms Act and TADA. Later he was acquitted from the kidnapping case, but he was convicted under TADA and Arms Act. This has been challenged before the Supreme Court. The Supreme Court set aside the conviction under TADA and Arms Act by applying atrocious acquit doctrine. Because in kidnapping, the person may kidnap another person for a reason. It may be for ransom. So in extortion, the person should put in a fear to extract or to take away the money or valuables from the innocent person. So here, for the purpose of extortion, he might have used weapons. So the possession of weapons is punishable under Arms Act and TADA. Now the main case is kidnapping and extortion. So the kidnapping and extortion is interrelated with the Arms Act and TADA. Then the court acquitted the person from kidnap case. Now the question arises, the important section which has been booked by the police on the accused person became acquittal. So in this situation, the other acts also can't survive without the main offense, because in main offense itself the person got acquittal. By applying the atrocious doctrine, the Supreme Court had set aside the sentence given to him under Arms Act and TADA. Concept is ingredients of double jeopardy. First ingredient is the case should be a criminal in nature. The second is the criminal case should be prosecuted and punished. In the first ingredient, it should be a criminal case. The concept of double jeopardy will not apply to civil nature. The second ingredient is criminal case should be prosecuted and punished. So the trial should be conducted and the accused person should get a punishment. Then only the double jeopardy concept will apply. If the person is released from the jail, the double jeopardy concept will not apply to him. The case can be initiated once again on the person. The third ingredient is the prosecution must be before the court of law, so that trial should be conducted by the criminal courts. The final concept is exceptions to Article 20, Clause 2. The first exception is acquittal from the case. If the person is acquitted from the case, the Article 20, Clause 2 will not apply. The second exception is if a person is arrested under preventive detention laws, Article 20, Clause 2 will not apply. Third one is disciplinary proceedings. For example, a government servant misappropriated funds in the office. For this offense, the concerned department will take a disciplinary action against the concerned government servant. Then the police officials file a case under IPC. Both proceedings can be simultaneously conducted. There is no bar for that. In this situation, Article 20, Clause 2 will not apply. The authorities have a power to give a punishment under disciplinary action. Similarly, he will get punishment under IPC in court also. Maximum in disciplinary action, they can dismiss a person from the service, or 2 or 3 increments may be decreased. According to the service rules, it differs. So, Article 20, Clause 2 will not apply to disciplinary proceedings.